Four business partners buy a commercial property together. Years later, tensions rise. One partner slides a sealed envelope under another's door. The very next day, a different partner suddenly dies. This sequence of events creates a complex legal knot, mirroring the fact patterns used to test your understanding of co-ownership. We have to determine, does the deceased partner's share pass to the surviving partners, or has the joint tenancy been severed? To solve this, we rely on the Dual-Estate Axiom. English land law demands a strict bifurcation. Ownership is always split into two distinct layers: the legal estate, which controls the paper title, and the equitable interest, which dictates the actual financial value. The legal estate operates under rigid rules. Under Section 1(6) and Section 36(1) of the Law of Property Act 1925, the legal estate can only ever be held as a joint tenancy. Furthermore, the law caps the number of legal owners at a maximum of 4 adult trustees. Importantly, the legal estate cannot be severed under any circumstances. The trustees are locked in a joint tenancy, and the right of survivorship dictates that a deceased trustee's name is simply absorbed by the survivors. Because the legal framework is locked and unchangeable, we cannot look to it to resolve disputes over the property's financial value. Every calculation regarding who owns what percentage of the money requires us to exclusively analyze the fluid structure of the equitable interest. Before we can figure out how a chaotic event altered the financial ownership, we have to establish the starting baseline. We do this using a progressive 4-step test: unities, declarations, severance words, and presumptions. Step 1 checks for the 4 unities: possession, interest, title, and time. If all 4 are present, an equitable joint tenancy is possible. We then immediately move to Step 2, checking the transfer document for an express declaration of how the buyers intended to hold the property. If the buyers included an express declaration stating they are joint tenants, the inquiry stops. The ruling in Goodman v. Gallant established that an express declaration on the deed is conclusive. This brings us to a common exam trap. Examiners frequently provide detailed facts about how the buyers made unequal financial contributions, trying to tempt you into calculating proportional shares. This textbook excerpt proves you must ignore that bait. Look at example B. Despite Harriet contributing 75% and Lottie 25%, their express declaration of a joint tenancy legally overrides their unequal contributions. They remain joint tenants. The foundational transfer deed dictates the absolute starting line of ownership. Initial cash contributions are irrelevant if the deed speaks clearly. However, while the starting line is locked on paper, future actions can shatter it. To protect their share from passing to other partners upon death, a co-owner must trigger severance. Severance is the legal mechanism that converts an equitable joint tenancy into a tenancy in common, isolating their share and halting the right of survivorship. The primary statutory mechanism for this is severance by written notice under Section 36(2) of the Law of Property Act 1925. To be valid, this notice requires an immediate, unequivocal intention to sever. The courts read immediate intention strictly. In Harris v. Goddard, a divorce petition requesting a future property adjustment failed to sever the tenancy because the intent was delayed. By contrast, in Reed Draper's conveyance, an affidavit stating "I am entitled to a half share" was immediate enough to trigger severance. But an intention on paper means nothing without delivery. This reached its peak in the case of Kinch v. Ballard. A wife mailed a valid notice of severance to her husband, but after the postman dropped it through the letterbox, she intercepted and destroyed the letter before her husband ever saw it. Look at how the text analyzes the court's decision in this case. The ruling relied on Section 196(3) of the Act. The court determined that the severance was effective because the law dictates a notice is validly served the moment it is left at the last known place of abode. The recipient's actual comprehension of the letter is irrelevant. The wife's change of heart and destruction of the document did not reverse the legal trigger. Ultimately, objective delivery is what satisfies the statute. A perfectly executed written severance is a unilateral, irreversible weapon. Once it lands at the correct address, it alters the asset's inheritance trajectory, securing that partner's financial share for their own estate. While written notice is the primary statutory tool, the common law recognizes 3 other methods: alienation, mutual agreement, and homicide. The nuances of mutual agreement are captured in this summary of Burgess v. Rawnsley. Mr. Honig and Mrs. Rawnsley orally agreed he would buy her share for £750. She later repudiated the unwritten deal, and he died 3 years later. Even though the deal collapsed and was never put in writing, the court ruled the joint tenancy was severed. The oral agreement provided a clear, objective indication of a common intention to sever their financial interests at that exact moment. When these methods successfully trigger severance, the resulting mathematics are rigid. The severing party fractures their specific portion away from the whole, becoming a tenant in common. Meanwhile, the remaining parties stay fused together as joint tenants over the remaining share. Crucially, the size of the severed share is calculated purely by the total number of original joint tenants. If there were 4 original partners, the severing party gets exactly 1/4. Initial purchase price contributions are ignored. Severance locks in an equal mathematical fraction of the asset's equitable value. By isolating their slice, the severing party detaches themselves from both the risks and the rewards of the remaining co-owners' survivorship pool. Let's apply these rules to the scenario we opened with: 4 business partners, a secretly delivered envelope, and a sudden death. We can now trace the exact final ownership percentages. First, we resolve the legal estate. Survivorship applies automatically. The deceased partner's name is removed from the title, leaving the 3 surviving partners holding the legal estate as trustees. Next, we calculate the equitable estate. The textbook confirms the partner who delivered the envelope severed their interest under Kinch v. Bullard, isolating a 1/4 share. But for the partner who died, the highlighted sentence confirms their unsevered share passes automatically by survivorship. This exposes a critical rule. You can never sever a joint tenancy through a will. The legal trigger for severance must occur inter vivos, meaning while the person is still alive. The deceased partner's last will and testament is legally irrelevant to the property. Final ownership percentages are dictated entirely by actions taken while the partners were breathing. We have solved the math. We know who owns what percentage of the property. But knowing the percentages doesn't solve the practical reality if the remaining co-owners are deadlocked over whether to sell the commercial building. When human disputes stall the management of the property, the Trusts of Land and Appointment of Trustees Act 1996, known as TLATA, becomes the primary governing framework. TLATA creates a specific balance of power. Section 6 grants trustees the sweeping powers of an owner, allowing them to sell or mortgage the land. But this is checked by Section 11, imposing a strict legal duty on trustees to consult beneficiaries and respect the wishes of the majority. If consultation fails and the deadlock remains, Section 14 allows any interested party, trustee or beneficiary, to apply directly to the court to either force a sale or prevent one. The court does not guess. Section 15 provides a strict checklist the judge must weigh, including the trust's original intentions, the welfare of any minors, and the interests of secured creditors. The mechanics of joint ownership are rigid. When they fracture into human disputes, TLATA 1996 provides the statutory safety net required to resolve the deadlock and restore equity.